Okay, hey, good morning, everybody. This is Larry Horowitz. I run CREC compliance, and I wanted to thank everybody for coming this morning. I knew it was a kind of a new day and age here when a good friend of mine sent me a cover of Queen's Bohemian Rhapsody sung to the tune of Coronavirus Blues. So if anybody on this call wants a copy of that, I'm more than happy to forward it along with our agenda as well. So if everybody can kind of take a look at the screen, we're going to go through this outline. We're going to do it fairly quickly and efficiently. Our purpose today is not to provide kind of a broad discussion about the legal ramifications of the coronavirus and the various kind of edicts coming from the government agencies. Instead, it's to be very focused and to provide a set of guidelines that deals specifically with cannabis operations throughout the United States. So if you take a look at our outline, that A there is kind of the key standard. That standard is a federal standard. It applies to everywhere in the United States. And basically that employers are obligated to provide, and I'll just read it, a work environment free of hazards which may cause death or serious injury. Now, no great surprise on that. But obviously in the context of the coronavirus, it takes a very different kind of view to all of it. And one of the things that we're seeing, and I'll get into it later, is we're seeing the plaintiffs bar now get very active to our industry and begin to kind of position for what will be eventual lawsuits related to some of this. And I'm going to talk about it as we go. So that first step there in that under B now, is can your physical location remain open as a matter of law? So in California, the answer is yes. At least as we sit, cannabis has been defined as a critical industry, and so the entire licensed supply chain remains open. But that does not mean that every cannabis business or anybody supporting cannabis operations is part of that critical industry supply chain. So as I indicate below there, if you're a cultivator, then we think it's very clear that you can legally remain open, but ancillary service providers like software, it's just not as clear. And so let me just keep going here, and we're going to talk about what the risks are. So if you stay open in violation of the law, where we are very concerned is that it is very clear that it's then strict liability. If somebody gets sick, if somebody, God forbid, is hospitalized, if somebody, God forbid, actually passes away from all of this, we all understand that, a lot of that is remote, but if it were to occur and an attorney was able to prove it, it creates, very serious legal exposure for operations. So our point here is if you're staying open in violation of the law, then you are strictly liable for whatever happens to your employees. And that's the very unpleasant kind of circumstance. So that last on number 3 there under B, where it says if you stay open as authorized by the law, what then? Well, we're going to cover 2 things here today. One, we're going to adopt some of the procedures, and we're going to talk about those that are suggested by the CDC. And secondly, and this is critical, we need to make sure that we are actively monitoring compliance with all of that, but perhaps just as important that we're documenting the efforts that constitute kind of the active monitoring. So when you get down there to number 2 below, and again, as I said, we're just trying to be very, very specific and focus upon cannabis business operations and what are the actions we should take to minimize legal exposure. And in the event, the plaintiff's bar comes knocking, have we properly documented the defense? So the CDC guidelines, I think we've all heard these things, right? It's 1 through 6 there. And there's no doubt all of these things are important, but there are 2 things that are critical. Number 1, in our view, you must provide a written communication to your employee, which documents the fact that you have communicated all of these guidelines. And by doing that, you accomplish 2 things. Number 1, you comply with the law, but number 2, you're now defining, okay, this is the guidelines under which, if you're going to come into the office, these are the ground rules as to what our operations are going to involve. And to a certain degree, what we would call that is a safe harbor, that if you're complying with all of these CDC guidelines as required by the law, if you're authorized to continue operations under the law and something happens, then you should have a defense so long as it's all properly documented. So if everybody could just kind of move that screen down a little bit, we'll get to some additional suggestions that we've kind of incorporated into our advice to our clients and customers. So as you can see, we've developed what we're calling a notification and waiver document. And it really is just a notification to the employees. And again, this goes back to documenting. Look, we provided you with the guidelines. You're required to comply with those guidelines. We're notifying you that, you know, this virus is out there and there's a risk associated with it. We're going to do everything we can to protect you. But if something happens, these are the implications of that. And you are to comply with those things as well. And again, we view that document as really important. And if anybody wants it, then just email us and we'll send you kind of our form. And while there's a certain question as to whether, you know, a true waiver of that is enforceable, the key here is to document the fact that all of those things occurred. We told our employees to comply with the CDC guidelines. We documented the fact that we're complying with the CDC guidelines, and we advised the employees if they're not seeing something that's in compliance, they need to notify us. So that number 2 there under B about these are kind of our additional suggestions is document, right? So have a sign-off sheet for the periodic disinfectants. Have a sign-up sheet if, for example, in some of the grows, people are using some basic, you know, protective gear, which include, you know, kind of, I've seen people use ski goggles and trash bags and things, and that's all good, and it's all helpful, but we need to document, you know, when was that done with, and I fully understand that that's a hassle. Can everybody still hear me? I'm seeing something on my screen saying I may have some internet problems. Can everybody still hear me, Roger?
Yeah, it sounds pretty good. You're breaking up a little bit. If we just pause for a moment, maybe it'll fix itself. Just talk a little bit slower.
Yep. So we document, and then we want to minimize contact between employees and other employees and the employees and customers as well. So, you know, in the cannabis industry, one of the suggestions is, well, don't take cash, have everybody process their own credit cards so that your employees are not, you know, exchanging things with the customers. And we all know that's, you know, very difficult in our industry, unlike other industries, you know, I might add. But all of those other things that we know, you know, no shaking hands, no, you know, periodic touching for whatever reason, and to the extent people can maintain the social distancing, those are the critical things. So again, just 2 pieces of this. We've got the CDC guidelines. We've got some suggestions from our compliance group, which include this waiver documentation. And then we have to document the fact that everybody's signing, everybody's acknowledging, everybody understands what this is. So if we could just go to number 3 at the bottom there and we'll finish up. And as I say, the key is to not become a target for the plaintiff's bar. And our background prior to the cannabis industry was as securities attorneys. And, you know, to a certain degree, there's an entire, you know, industry out there of plaintiff's attorneys that are just waiting for our clients to make a mistake. And sadly and unfortunately, this appears to be the case with this as well. We're seeing some of the plaintiff's attorneys kind of ping the employees of some of our clients, asking, you know, what's going on? Are they doing this? Are they doing that? Please reach out to us if you have any concerns. So as I say there at the bottom, we will be held strictly liable for CDC compliance if something happens to one of the employees. And finally, as I think I've stressed in this, you know, brief conversation, we need to document. And if you don't entirely understand that, it certainly starts with this acknowledgement that we've generated, just, you know, disclosing to the employees, hey, if you're going to come back to work, here's the environment into which you're going to be, you know, kind of operating, and that it's different. And some of what we've got there came from some of the grocery stores. Because if you've come into the grocery stores, as I said, some of them are no longer taking cash. Some of them have protective barriers, kind of plexiglass between the employee and the customer. And the concept is that the customer and the employee should not be exchanging anything. And again, the way I think this is all going to shake out, and then we're happy to cover any questions, because what we really wanted to do this morning was just provide a very brief, practical kind of emergency communication as to what we would like to see our clients do, to provide some very practical, specific guidelines as to what that should be, and then just to alert to everyone that we are seeing, you know, the proverbial vultures begin to kind of circle around our industry. And I just want everyone to be aware of that, that we're not, you know, kind of flying the, you know, the red flag here just to fly the red flag. And there's no doubt, I mean, I think we're all in agreement that this is something very real and something very scary. But then on top of that, we've got, you know, attorneys apparently watching at least some of our movements. And so the key to that is when and if there's, you know, claims against the company, that we have evidence that to the best of our ability we complied. And so to kind of finish this, if you're complying with the CDC guidelines and you're providing that notification that I kind of, you know, summarized, then in our view, it is no longer strict liability. If somebody gets sick, we certainly have defenses, and we can, you know, we'll deal with those defenses when and if there are claims. So I'm happy to cover any questions today. And as I indicate at the bottom, if you could please use that email address, jared@crec.us, with any other questions or comments, or, you know, if you'd like to get a copy of our notification, then happy to provide that. So Roger, are we seeing any questions, or can we sign off
Yeah.
this morning?
Yeah, as a follow-up to that, we will be sending up the notes and a recap of this webinar after as well. So please reach out to Jared if you have any other questions you'd like us to answer, any other compliance questions. He's very quick. We have a couple of questions, but I had one that I wanted to go into quickly with you, which is there a point where people should stop documenting? Is there something that, you know, they can look for that means, okay, we're good, we're solved, it's time to stop documenting?
When you say, is there a time, in my view, it should be on at least a daily basis, or even more frequently. That, you know, I think, I don't know if anybody's seen, like, restaurants, there'll be a sign off when the employees are cleaning the bathroom. I'd just like to see something like that on the disinfectant. So when you say, is there a time when we can stop, that's going to be driven by the CDC and the government agencies as to what the communications are. But, you know, in terms of protective equipment and the disinfectant, those things I think should be done, you know, periodically every day. And then as to that notification, that's just kind of a one-time event.
I'm going to put the next question on here. Okay, due to being federally illegal, it seems that cannabis companies will not be eligible for federal assistance. Also, personally, with my income artificially inflated due to 280E, I may not be eligible for assistance either. What options can we create? Thank you, Peter.
Well, you know what? That is a great question. And part of the answer, unfortunately, is no one knows, because when you take cannabis, couple it with federal illegality, coupled with a worldwide pandemic, that's not something that's generally taught in you know, seminars or otherwise. But let me try and summarize some of this. I do believe that all employees will be entitled to unemployment. I think that's clear, so long as you've been paying into the pool. Secondly, in terms of the artificially inflated 280E, there's you know, there's two different issues there. There's one, there's the personal income level, which may or may not be inflated due to 280E because you may have a pass-through entity, right? And yes, that is an irreconcilable problem. But then secondly, you know, there's the loan availability itself, where you know, the performance of the company being inflated might very well be helpful. What's not clear is whether these SBA loans are now going to be open to cannabis companies. I haven't seen anything on that one way or the other. So when you say what options can we create, certainly all employees are eligible for unemployment. They're all eligible for these, you know, below $75,000 and whatever it is, I think $125,000 for couples subsidies. And then for the company itself, I think it's going to be a lot more difficult. But I will make one other comment, and then we can move on. You know, our industry at some level, and this is unbelievable, is actually being allowed to stay open. And so a lot of the financial hardship that, you know, most other industries are experiencing, we're not seeing that yet in the industry, and we're not seeing it yet in our client base.
Okay, we have 2 other comments. If you guys have any others, oh, we have 3 more. Please ask your Q&As in the Q&A section of the webinar. Jeff T is asking us to send the Rhapsody clip along with the agenda. Thank you, Jeff. We will be sending all of that after. Okay, here is a question/comment from John Armstrong for you to react to. Remember, most of the job injury claims, including contracting the virus, would generally be covered by workers' compensation. Employees would have the burden of showing that the employer engaged in serious and willful misconduct in order to get out the limitation of workers' compensation. Larry?
I think that's a good comment, and that's kind of the point, is that if you're operating outside those CDC guidelines, then you're almost, as a matter of law, creating it's serious and willful misconduct. And now you're operating outside of your insurance policy.
Okay, Hank asked us, how about the Family First Act? How does that affect us?
Well, I'd like to answer that question if I knew what the Family First Act was. Does anybody else know? I guess I can look it up as we sit.
I'll ask you the next question and I can give you a debrief in a second.
Okay.
Sharon says, thank you for your time today. Stay well. Thank you for joining us, Sharon. Please stay in touch. We have another question as well. 1 second, please. Since CDC is not an actual government agency, quasi-private government like Johns Hopkins, do you see this a way that SPAC will provide relief to CANA future suits?
No, I don't. Because certainly when we see, for example, the orders coming down from, for example, Governor Newsom, they're certainly referencing and incorporating the CDC. So no, I think we're very comfortable that the CDC guidelines will provide a very important defense in the event that there are claims. And I am looking at what the Family First Act is. I understand what it is now. So I think that it is available to all cannabis employers within the state of California. Whether it's the case in other states depends upon how they're setting up with the way they're working the federal and state, kind of conflict. Okay. One of the most interesting, so I'm looking at Miklos's question, which is, would a thermal video feed like they do in Asia help protect a cannabis business from liability? There's a really interesting technology, and just real quick, that has basically thermometers that then feed data into your phone, and then they're able to actually, develop heat maps. And I just saw something 2 days ago which said Florida is going to be the next hotspot because they can see that the temperatures are going up. And so certainly I don't, a thermal video, you know, I don't know that anybody's set up for that, but certainly taking people's temperatures when they come into work each day, that's an example of documenting, you know, what's happening at the office itself. And to the extent people are showing a fever, then they're sent home. But sure, anything like a thermal video feed or anything that's showing diligence on the part of the company is going to be helpful.
Thank you, Larry. Can we circle back around to Hank's question? Are people going to be on the hook for 80 hours of sick pay? Larry, are you still with us?
Yeah, I'm looking at it. Guys, Mr. Casillas, I'll have to be back to you on that. That one is something that we haven't examined, but it's a good question.
Great. Is there anyone else with a question before we finish up the webinar? And if you have any others afterwards, please remember to email jared@crec.us. Last call? Okay, thank you everyone for joining us today on our emergency webinar about cannabis and COVID-19. We look forward to staying in touch, and please learn more about the CREC network, CREC portal, and all of the great services that we're offering for real estate agents and cannabis professionals. Thank you for being here as well, Larry, and spending your time to help support our audience. Have a great day, everyone. Stay safe, stay indoors, wash your hands.